Now let's talk about New York State medical malpractice law. As I just mentioned, there is essentially a 2.5 year statute of limitation, and in general, there is no discovery rule. Most states have a discovery rule where you have a certain amount of time from when you discovered the malpractice. New York State does not. It's one of about 5 states that doesn't. So in other words, if you haven't found out about the malpractice during that 2.5 year period of time, you're pretty much out of luck. There are exceptions, of course, which we'll get to in a minute. Now, in 1975, the statute of limitations was reduced from 3 years to 2.5 years, which frankly is kind of an oddball number, but apparently the medical community in New York State had a pretty powerful lobby to get them to reduce it by 6 months. Obviously, that was a good deal for doctors and a pretty bad deal for patients. But like any rule, there are exceptions. As a matter of fact, recently the state of New York passed a discovery rule when cancer is involved, because many times, if that's misdiagnosed, you don't know years later till you had it. So they're allowing for a discovery rule in that case, but that is only recent. However, there are other exceptions. One is if a foreign object is left in a patient after an operation, such as a scalpel or a sponge, and it isn't discovered till much later, well, then the statute of limitations is told. There is another exception, however, and this has to do with the doctor's fiduciary obligation towards his patient. It is an established legal fact that a doctor has a fiduciary obligation to put his patient's welfare before his own. In other words, if the doctor commits medical malpractice and is aware that he has done so, he must inform the patient of the malpractice so that the patient can correct the medical problem and initiate a timely lawsuit against the doctor to recover compensation and/or damages. If the doctor fails to inform the patient of the malpractice and tries to cover it up by fraudulently concealing or misleading the patient in order to run the clock out on the 2.5 year statute of limitations, the doctor can no longer hide behind the 2.5 year statute of limitations, and as a matter of fact, the statute of limitations is told for 6 years past the date of discovery of the fraud, which in this case would be the malpractice. Critical case law in this area was established in 1978 in the landmark case of Sukumski versus Sayeli. This is a critical decision in the state of New York, which is used not just in medical malpractice cases, but this is cited in fraud cases all over the place in the state of New York. In that particular case, Dr. Sayeli operated on Mrs. Sukumski, I believe, in 1970. He performed some sort of operation on her face or neck, and during the surgery, he accidentally severed a nerve, and he was aware of what he had done. After the operation, Mrs. Sukumski told Dr. Sayeli she was having numbness in the area, and he told her, instead of being honest with her and telling her what happened, he told her that she needed physical therapy and various other treatments, and eventually it would clear up, which was a blatant lie. Well, this apparently went on for approximately 4 years. Finally, after 4 years of no improvement, Mrs. Sukumski got a second opinion, and that's when it was discovered that the nerve had been cut. So she found an attorney who filed a lawsuit against Dr. Sayeli. Well, the discovery of this was 4 years after the operation, and she hadn't seen him apparently in all those years, and the statute of limitations at that time was 3 years past the date of last appointment. So what was Dr. Sayeli's defense? Well, the statute of limitations expired, of course. You know, it had expired 1 year prior and was time barred. The trial judge apparently agreed with that assessment. So her attorney filed an appeal. And it turns out the New York State Court of Appeals reversed and said that there was more than enough evidence to indicate that Dr. Sayeli knew exactly what he had done, and instead of informing the patient of what he had done, he tried to cover it up and mislead her for all those years, and therefore the case was not time barred, and it was sent back to the trial judge. They also determined that the statute of limitation was told for 6 years past the date of discovery of the fraud, which in this case would be the malpractice. So this is obviously a very powerful piece of case law that benefits patients who have not been to the doctor in the last 2.5 years, when the doctor is fraudulently concealing his own malpractice. So, how does this relate to the Dr. Holland case? Well, Phyllis didn't see Dr. Holland within the last 2.5 years. Her last appointment was in fact 2 years and 10 months. Therefore, the only way to get this case into the courtroom, obviously, would be to have the statute of limitations told. And we now have critical case law that allows that to happen in the Sukumski case. In the Sukumski case, the malpractice was unintentional, but the cover-up was intentional. In the Dr. Holland case, the malpractice and the cover-up was intentional. Furthermore, Dr. Holland's actions were a heck of a lot worse than Dr. Sayeli's. I mean, Dr. Sayeli basically told this woman, to get physical therapy. Dr. Holland, however, engaged in numerous fraudulent and malicious acts starting before he even operated, designed to cause Phyllis's death and ultimately get away with it. I estimate he performed a minimum of 15 to 20 fraudulent and malicious affirmative actions designed to cause Phyllis's death and cover up what the doctors were in the process of doing to her. So Dr. Holland's actions were a heck of a lot worse than Dr. Sayeli's, that's for sure. Now, in the Sukumski case, the patient hadn't seen the doctor in 4 years and the statute of limitations was 3, so the statute of limitations expired 1 year prior. In the Dr. Holland case, Phyllis didn't see Dr. Holland in 2 years and 10 months, 4 months past the statutory deadline, but this is a full 8 months less than in the Sukumski case. This is a powerful legal argument that clearly should have been made. I mean, you can't even compare the two cases, frankly, since Dr. Holland's actions were a hell of a lot worse. Furthermore, he wasn't operating alone. Dr. Klein filed 2 falsified reports, so he was obviously clearly involved in the operation and the cover-up. But clearly, both the other 2 surgeons and the hospital should have both been sued. So let's look at some of the dates now. The lawsuit that was originally filed by Jethro Eisenstein, Ted Friedman's part, was filed in August 1985. Preston J. Douglas took over the case in January 1989. That's 3.5 years later. Let's assume the fraud or the malpractice was discovered in August 1985, although due to the technical parameters of the case, it probably could have been argued that it wasn't discovered till later, but let's use that date. Preston J. Douglas took over the case in January 1989. That was 3.5 years later. Assuming a 6-year statute of limitations, that means there were still 2.5 years left. Plenty of time to get this case into the courtroom. So we have powerful evidence indicating Dr. Holland engaged in fraudulent and malicious activities over an 8.5 year period designed to cause Phyllis's death. Everything he did was designed to make the condition worse, prevent Phyllis from seeking corrective treatment, and to cover up what he and his associates had done so it would not be discovered in a timely manner by either Phyllis, her family, her personal physicians, or anybody at Mount Sinai Hospital, such as the consultant. So, and now we have powerful case law to back it up, Sukumski versus Sayeli. So we have a strong evidentiary case, and we have a strong piece of case law to back it all up. Now let us take a look and see how exactly Preston J. Douglas handled the case.